Hello, and thank you, everybody. So as Kelly said, I am Jennifer Schultz, and I am with Community Legal Services. Actually, Kelly, I'm trying to send an item to the chat, and I'm having a problem doing that. What should I be pushing there?
In the chat box, you want to click on More to the right-hand side and
Okay.
share a file in the meeting, bring up the file, and then you would just hit share, I believe it is, or whatever.
No, I just want to send a comment that I chatted, like
Oh.
not a file.
You would have everyone type the message and then just hit return, and that should send it.
Oh, there we go. Okay. Hopefully everybody saw that. So that chat box is where you can ask questions as we go through today. Please feel free to ask them as we're going. No need to wait until the end. And as Kelly said, today we are going to be learning about bankruptcies with an emphasis on Chapter 13. And as my first slide indicates, this is a comprehensive discussion of screening clients, preparing filings, representing clients in court, and options for homeowners. So obviously at the end of 1 hour, you guys are going to know all of that, or maybe not. I think we have a poll we want to send out. I want to get a feeling for who we have in the training today. So if everyone could just give me an idea about who I'm talking to, that'll help me tailor what we're talking about. So I do want to emphasize that this is an introductory webinar. It's an hour long, and there is no way we're going to finish everything that you need to know in an hour. So after this training, we actually will have a second webinar next week, or sorry, is it the week after? I think it's 2 weeks from now. And we're going to talk more about how to actually prepare the documents and the forms and what the early stages of bankruptcy actually look like. That will be our next webinar. And then after that, there's going to be an all-day training in Harrisburg in March. And my colleagues, Mike Froelich and Jonathan Scrow, will be covering the more extensive pieces to representing homeowners and mortgagors inside of bankruptcy, and the various motions, proofs of claims objections, adversary proceedings, and how to do a Chapter 13 plan. So the purpose of these two webinars is really to give people a foundation so they can understand when they're going into that more extensive training that will be in March. And today, we're really just going to talk about how bankruptcy works and what to be thinking about and when bankruptcy makes sense for a particular client. So it looks like I have a lot of attorneys in the room and a couple of paralegals. I know there are a few folks who haven't responded, but that's okay. So the next poll that we actually have is about your familiarity with bankruptcy. And I'll do share results for that first one. So let's see.
I've launched it, Jennifer.
Yep.
We're just letting people respond now.
So a few things to understand about bankruptcy. If people have done them in the past, I see a few people have. There were substantial changes to the bankruptcy law in 2005. So it's important anytime you're working with bankruptcy, if you're looking at something, information or cases that are before 2005 or involve a case that was filed before 2005, that there are a different set of rules that we are following today. And that law was called the Bankruptcy Reform Act. And for our clients, it didn't make a significant amount of changes. There'll be a few items that we'll talk about, which is the credit counseling before the bankruptcy and the debtor financial education. And it means we have to submit more documents. But a lot of the concerns that people talk about with that Bankruptcy Reform Act really don't apply to our clients because our clients tend to be so low income and have very few assets. I do see that a few people have done a bunch. The pros in the room, I see a few people who are pros. You probably aren't going to learn a lot today. This is the intro level class. So please feel free to offer your own comments as we go through in the comment section. I invite anybody who has more to share with this. I know I certainly can't remember everything to include. So the first thing to understand about bankruptcy is what it is. And bankruptcy is something that's actually allowed within our Constitution, and it's designed to protect people from creditors. It's designed to offer a clean slate for people's debts, although in practice there are exceptions, so that's not always a final result, and we'll talk about that as we get further along. And what the real purpose of a bankruptcy is to create a forum where the debtor goes and asks for help and brings all of their finances into the forum of the bankruptcy. And then they apply a single set of rules to resolve all of the various debts and obligations that this individual is facing. And in theory, what should happen is that the debtor hands over everything they own. It gets divvied up among the creditors, and they get their pieces according to the rules of priorities. And then whatever isn't paid is considered wiped away, discharged. In practice, that's not actually what happens, don't worry, because our clients don't hand over everything they own. There are a list of exceptions, exemptions, that allow people to keep a lot of the things they own. And a big part of what we are doing as bankruptcy practitioners is making sure that we maximize the exempted assets so that our clients have little or no obligation to turn over any assets as part of the bankruptcy process. And for our clients, that's usually a really easy job to accomplish because because our clients tend not to have acquired many assets, or by the time they get to us, they may have already fallen away from those assets in various methods. The biggest issue that we need to look for, particularly because our emphasis today is mortgages, is equity in homes. So I always use the number 25,000 as the exempt amount. That's not the exact number. It changes every year. I have not looked up the amount for this year, but it's pinned to an inflation index. So it goes up a little bit each year and how much that's exempted. But when you're doing the back of the napkin calculations, looking at a case, you can use 25,000 as the amount of exempt equity in a home. So if your client only has $10,000 of equity in his or her house, you don't have to worry. But if your client has $50,000 of equity in the house, that creates a lot of other considerations that you have to look at. I mean, that's really a situation where you want to put the pause button on the idea of bankruptcy and look at everything very, very closely. And if they're in that gray area where they're around 25,000, maybe they're 26, maybe they're 23, that's where you want to make sure you're getting your numbers accurately and that you're doing that equity computation correctly, and also looking up the exact exemption amounts. And if you have a couple who owns the house, you can, double up on those exemptions. So there are different ways to run that math. And a lot of what we do is understanding the rules and then figuring out how we do the math so that it applies correctly to all of these rules that we're talking about today.
Jennifer, okay. We have somebody sent something in the chat that says exemptions change every 3 years and are scheduled to be adjusted in April of 2019.
Okay. All right. I thought there was an annual update on them, but if it's 3 years, that's fine too. Just as a practitioner, if you're using a bankruptcy preparation software, you want to make sure that software is getting updated annually so that you have the accurate numbers in the software. And for the most part, it's not something that we run up against too often. If you know the rough numbers, then usually you're not going to have a problem for our cases. And when you need to know the exact number, that's when you go to the reference materials and make sure you have exactly the correct information. So that's why I don't, but thank you for that. I appreciate that, Catherine. Okay, so the other thing to understand about bankruptcy is it's not a magic bullet. There are a lot of misconceptions from people in the mainstream who walk into an office and think, I'm going to file bankruptcy and I'm going to be okay. And it's going to be and it's super easy. And sometimes they think they're going to walk into our office and walk out with their bankruptcy done. And that is just not how it works. And hopefully as we get through today and our next webinar, you'll understand there are a lot of steps. It's a complicated process. It involves a lot of disclosure of a person's finances and a lot of participation on the part of that individual. And so it's not something that should be entered into hastily, without thought and without consideration. It really is a process that a person needs to be committed to. Doubly so when we are talking about a Chapter 13. And anytime you're trying to resolve a mortgage problem, you're talking about a Chapter 13. And a Chapter 13 bankruptcy involves a plan, and it's a payment process of 3 to 5 years. And so that means you're going to have that client, when you take that case, you're going to have that client for between 36 and 60 months once you file that bankruptcy. So there's a long commitment process to participating in that. Okay. All right. So we can go ahead and close that poll. So why do we as practitioners want to use bankruptcy to help a client? It has this incredibly powerful piece that comes with bankruptcy. So the way that you initiate a bankruptcy is through filing a document called a petition. So when we talk about bankruptcies, we talk about pre-petition, referring to before the bankruptcy was initiated, and post-petition, referring to after the bankruptcy was initiated. When the petition is filed, there is this fantastic power that comes with that moment when it gets date stamped. And in the old days, it used to actually be a stamper, and now we have the electronic stamp when we click the file button on our ECF. And it creates an automatic stay. So the moment that a petition is filed, the bankruptcy court automatically requires all creditors to discontinue all collection activities. And that is an incredibly powerful tool that we have that changes the balance of power between the relationship of our clients and their creditors. So it has the ability to do things like stop a court case, like a foreclosure, and including the sheriff's sale. So you file the bankruptcy at 11:59 p.m. and the next day of the sheriff's sale, you fax it over to the sheriff's office and call them up and make sure they looked at their fax, and that sheriff's sale does not happen. Even if for some reason the information doesn't get to the sheriff, if the sale was performed after the stay was in place, you can actually unwind that sale because it was not a valid sale. If there's a wage attachment that's being done against your client's wages, the automatic stay stops that. It's the same thing if you have a bank account that's been attached through a judgment collection process, or if a client is facing the repossession of a vehicle. All they have to do is waive that bankruptcy paper, and that car has to come off of that tow truck, and they get to keep their car, at least for the moment. Okay, so the automatic stay does not equal final remedy. A lot of people, lay people, misunderstand that, and they think because they've had this magic resolution where all of a sudden all these problems stop, that it means everything's okay. But the reason this automatic stay exists, it's a pause button. And it's designed to say, okay, we don't want creditors, once the person requests the help of the bankruptcy process, we don't want creditors resolving the debts outside of bankruptcy. Remember, the whole concept of bankruptcy is that you bring all of those various debts into the bankruptcy forum, and you create a comprehensive plan for addressing all of the creditors according to the rules of the bankruptcy process. So if you have creditors outside of the bankruptcy helping themselves to various assets, it creates a problem that prevents the bankruptcy court from properly administering the bankruptcy. That's why the automatic stay takes effect. But there are ways that stay can stop, and then everything goes back to where it was, unless the bankruptcy has actually solved things. So the stay is just a pause button. That's when the real work begins for us as practitioners to actually get to resolutions. Once you're inside a bankruptcy, what people really want, what we all are trying to get to, is called discharge. That's when the bankruptcy process is complete, everything has been done as required, and the court issues an order of discharge that removes the legal liability of your debtor from paying on those debts. They know once that discharge order is entered, that person no longer owes any of those pre-petition debts. And I say any, but there are some exceptions to that we'll talk about in a little bit. There are other powers within the bankruptcy that we can use in the process of resolving debts. One of those is called the avoiding judicial liens. And you can do that even if, so the thing to understand here is if your client has a credit card debt and they get sued for that credit card debt and they lose, and there's now a judgment in the state of Pennsylvania, if it's in the Court of Common Pleas, it becomes an automatic lien against all real property that that client owns in that same county. If it's an MDJ judgment, all that needs to be done is the judgment creditor takes that judgment and records it in the Court of Common Pleas. Same thing happens now. It's an automatic lien. And similarly, if they want to take that judgment from one county and record it in the Prothonotari's office of a different county, it can then lien any property in that second county where they've recorded that judgment. So when we're looking at how do we sort out all of the debts that our clients are dealing with, if there's a judicial lien, one of the things we can do if that's impairing, if it's wholly unsecured, or if it's impairing the exempted value of equity in the person's home, we can actually remove that lien from the property, and then it becomes unsecured debt. And again, that would happen upon discharge. And in the in-person training, they'll talk more about that process. Within a Chapter 13, the primary thing that you're trying to get to is what's called a confirmed plan. You build a plan. It's a formal document called a Chapter 13 plan, and within that plan, it defines how the creditor, how the debtor is going to resolve all of the debts that are in the bankruptcy. And the key piece of that is the debtor has to commit to making a monthly payment into the bankruptcy, and then that money gets distributed to address the debtor's debts. And that Chapter 13 plan sets out the way that the money will be distributed. Another power within a Chapter 13 is that sometimes you can modify a debt. This can be a very powerful tool when you're dealing with car loans. And I know that we probably don't do a lot of bankruptcies for specifically cars, but sometimes those car loans are what's breaking our client's budget. And if you can just fix that stupid car loan with that 20% interest rate that still owes $15,000 on a car that's only worth $8,000, maybe the client might actually be able to get somewhere with the rest of their bills. So in that, what you can do in that process is called typically a cram down, where you can reduce the interest rate to a market rate rather than that inflated interest, and you can pay only the amount that's actually secured, the value of that security, rather than the full amount that's underwater. There are special rules about cars. We're not going to get into those. I can't remember if it's 910 or 920 days. But if you're trying to do stuff with cars, you've got to look up that rule, because you can only do it for older car loans. You can't do it if your client goes and takes out a car loan the week before you file the bankruptcy, or even the year before you file the bankruptcy. It's got to be almost 3 years old before you can do that, or 2.5.
Jennifer?
Okay, yes.
We have a question.
Certainly.
But if there is no property at the time of the lien, then do you still try to set it aside?
So the person who asked that question, I don't know what you mean if there's no property. What property are we talking about? I'll let you answer that, and I'll keep going, and then circle back when we find that answer. The other thing that you can do inside of a bankruptcy is you can bring legal actions, which may have time bars. There's a process called an offset. So if you owe a debt to a creditor, and you could potentially sue that creditor for something they did wrong in the creation of that debt, you can do that inside a bankruptcy, even if you couldn't do that outside of the bankruptcy. And that's where, with mortgages, if you find a TILA violation or a RESPA problem that's outside of the statutes of limitations, sometimes you can still bring those inside of the bankruptcy. And that can be a powerful tool to addressing an overall mortgage problem. And again, that's something that will be talked about more in that in-person training. Okay.
Before you start the next slide, he wrote back, if isn't real property at the time of the lien, then do you still try to set it aside?
Okay. Oh, so that's a good question. All right. So there is no lien if there's no property. It has the potential, if you have a judgment, and it has the potential to become a lien. So if the person purchases any real property, then that judgment would automatically become a lien against that real property. That's why mortgage companies make you pay off your judgments before you can buy a house or take out a mortgage. But there's no lien to avoid if there's no property that it's liening. So to answer your question, no, in your scenario, you would not avoid the judicial lien because there's nothing to avoid. Now, here's what would happen in that instance. You file the bankruptcy, you finish it, and you get the discharge. So at that point, the judgment no longer is owed. And so the discharge resolves that judgment and it's no longer collectible. But if it's against real property, you have to address that lien separate. And that's actually something that's really important to help people understand. The bankruptcy process has a lot of weird ways of cutting up problems. Okay, so you could kind of ask, well, wait a minute, if a discharge gets rid of the judgment, why is there a lien that I have to resolve separately? Because the discharge discharges the debtor's personal obligation to pay. But secured debts are treated differently in bankruptcy than unsecured debts. So a lot of what we do is spend time figuring out what do you owe that's unsecured, because that's just going to go away unless it's a special kind of debt. And then the secured debts are typically where we spend all of our energy in the bankruptcy process, because if you don't address your secured debt, the creditor gets to take the security back. It doesn't, security interest against the thing, whether it's the house or the car, does not go away through a bankruptcy discharge. So you have to have another plan to deal with that, like through your Chapter 13 plan. So, and I know it's a little hard to kind of create the full picture, and so if it feels like we have a lot of different pieces we have to put together before the full picture makes sense, but hang in there with me. We're going to get there.
And I'm going to go ahead and launch the first poll. If you're an attorney and you would like to request for one substantive, CLE credit for your webinar participation, please respond now. Thanks, Jennifer.
Absolutely.
You're free to go ahead.
Thank you. Okay, so we've talked about a couple of different kinds of bankruptcies, and I just want to make sure we have the same vocabulary. So there are two primary bankruptcy types that we work with. It's called a Chapter 7 and a Chapter 13. And so the Chapter 7 is the traditional kind of bankruptcy, that liquidation. So that was that very early example I gave, the idea that you hand over your stuff, they divvy it out among your creditors, and everything's called even. That's liquidation. But remember, there's a list of exemptions, and your client gets to keep those exemptions, and our job is to make sure everything they own is exempt as much as we can. So then on top of that on top of that liquidation model, which is kind of the core bankruptcy model, they've then built this alternative process called Chapter 13, which is reorganization. And the purpose of reorganization is to allow the debtor to rewrite the terms of their debt to resolve all of their debt, okay? And that's why within a Chapter 13, you have the power to do things like pay less than the full amount you owe, or change interest rates, or redefine the monthly payment that you will make to them. Or the really powerful one that we use all the time is catch up on missed payments. Okay, that is why we do bankruptcies to save homes. If our client is $10,000 behind in their mortgage, they don't have $10,000. The mortgage company isn't giving them a workout. So how do they resolve that? Well, where'd my calculator go? Here. Sliding with me. Sorry. So what you can do in that context is you take the $10,000 that they're behind, and let's say you want to do a 5-year repayment plan inside of the bankruptcy, so that's 60 months, and that gives you a monthly payment of $166. So inside of a Chapter 13 bankruptcy, they can say, hi, mortgage company, you know that $10,000 that I owe you that you want right now? You're not going to get it right now. I'm reorganizing my debt. So I'm going to give you $166 every month for the next 5 years, and then you're going to have that full $10,000 that I owe you. And don't worry, I'm still going to make the new payments each month when they become due. But to catch up on that $10,000, even though the loan documents give you the right to all of that money right now, the bankruptcy laws say you're only going to get $166 a month from my catch-up payment. That's why we use bankruptcies to save homes. And then it gets a lot more complicated than that because, you know, you're going to fight about whether or not it's really $10,000, and you're going to fight about whether or not there is equity that requires you to pay other debts in the process. And if you can find some way to offset, maybe you want to say, I don't really owe you 10 because you committed a TILA violation and you owe me $2,000 in damages, so it's only 8 after I offset that. That's what you do in bankruptcy. You figure all that stuff out. You go in and you hash it out, and you get the judge to tell everybody what the final decision is if you can't work out the deals, and then you write all of that into your plan, and then your plan will define what's going to happen in that reorganization once it's confirmed by the court. And that's really the goal in a bankruptcy in 13, to get to a confirmed plan where you finally have a comprehensive way that your client is going to be resolving their debts.
Jennifer, we have a comment. Trustee fee is included in 13 plan?
So it must be, yes. I was trying to keep the math simple for today, but you're keeping me honest. So it actually, you have to pay more than $166 to the trustee, okay? Because you have to you have to pay the trustee some money as well. But we're going to talk about that when we get into the next webinar in more detail. Okay. And again, a big part of why people go to bankruptcy is for that discharge. All right. When you get to the end of the bankruptcy and the judge says you are discharged, it means a lot of different things. And part of what it means is that you've done those catch-up payments and you're good now. And it also means if you have other debts that are what are called dischargeable, capable of being wiped away through the bankruptcy process, then you no longer owe those. So there are these exceptions to discharge. I had mentioned this, I alluded to this a little bit before. So there are certain debts that do not go away in a discharge. So even if you have these debts, you can go through the bankruptcy, you can get the discharge order, but you still owe this stuff. So there are IRS debts. There are some tiny little rules, like people who do IRS work know that there are some ways you can make them go away in bankruptcy, but it's tough, and you should never presume that an IRS tax debt is dischargeable. Domestic support obligations, child support, maintenance, and alimony. If that's why your client's walking in and asking for a bankruptcy, tell them go away, because that's not what bankruptcy does. Government fines, penalties, restitution, and forfeiture fees. There's currently a case in front of the Pennsylvania Supreme Court about exactly which of these are dischargeable and not. So we should check back. I'm sure you'll be seeing more of that on the listserv, but I think it has to do with when, I actually forget the details of it, but for the most part, if your client has criminal debt, a lot of those charges inside a criminal debt are non-dischargeable, but some are. So like, for instance, court costs. You'll notice court costs are not listed in there because those are dischargeable, but the courts never know that. It's really complicated to get them to honor that. Fraudulently incurred debts. So the way that we would most likely run into this would be if you have a client who has been accused of welfare fraud or Social Security fraud, not just overpayment, but where their accusation is that they were knowingly giving false information for the purposes of obtaining benefits they were not entitled to. In those instances, those are not debts that can be discharged in bankruptcy. I have encountered this because we do work with scammers. And so sometimes they think they're going to go to bankruptcy to get away from us. And then I show up and remind the court they can't do that. Debts for injuries, that's personal injuries related to DUIs. I went several rounds with a plaintiff's attorney who insisted that my client could not discharge property damage debt from a DUI they were wrong. This is specifically limited to damages related to injuries from DUIs. So, you know, we normally don't run to bankruptcy for DUI stuff to begin with. But if that's part of the full picture when you're taking the interview and you find this other debt floating out there, if it's not related to injuries, it's still dischargeable. But if it's, you know, a tort issue, you're not going to be able to get rid of that.
Jennifer,
student loans.
Sorry, a comment. She said listserv. Is there a planned bankruptcy email serve?
No, I think it's under consumer. I think bankruptcy questions normally are done there.
Yeah. Thank you.
Okay, student loans. There's a big asterisk next to that because there is a hardship exception to the student loan exemption from discharge. So what that means is if you've got a regular client and they have student loans, the presumption is they do not go away. They are going to survive a bankruptcy. However, if there is a situation where your client is not capable of paying them, will never be capable of paying them, and they're creating a hardship, and there's a whole other set of rules that you have to go with in order to qualify, you can go and do an adversary and specifically have a judge say that they are allowed to discharge those debts under the hardship exception. So, you know, I also do work in the student loan area, and sometimes we do look at this tool. It is difficult. It is very difficult to do discharges of student loans, even under the hardship exception. But don't discount it. Don't ignore it if it's a possibility. Okay, and then debts not listed on your bankruptcy schedule. So the schedules are the papers that you do in the bankruptcy. Our next webinar will focus primarily on those schedules, what goes on them, how you do them, and so forth. If you leave stuff off of those schedules, it can impair the ability to get a discharge. And there's a whole different set of rules around that. But basically, your goal when you're preparing those papers is don't leave anything out because it can harm the client and their ability to get the benefit of the discharge. So what things bankruptcy cannot do? We've talked a lot about this idea of non-dischargeable debts. So if someone has non-dischargeable debts and they want bankruptcy help, it's not the right way to get the help they need. It's not going to save everything from their creditors. If your client has non-exemptable property, they're going to have a problem. And, you know, understanding what the list of exemptions is and making sure that your client does not have assets that are going to be unexempted is a key part of any bankruptcy preparation. And again, the biggest way you can get into problems here is typically going to be the equity in our clients' homes. If they have too much equity in their home, if they've been really good and they haven't put a lot of secured debt on their house and they own a $100,000 house free and clear, bankruptcy may not be where they need to be because you know you wind up in a bankruptcy and then all of a sudden the trustee is talking about selling their home, and that's the power the bankruptcy court has. Because just as much as the court has the power to tell creditors not to come after your client, it also has the power to control all of the assets that your client owns. It's called they become the assets of the estate of the bankruptcy, and it's the job of the bankruptcy process to identify and maximize the assets available for distribution to creditors. So sometimes people think that, oh, I've got bad credit, I want to fix my credit, let's do bankruptcy. So it can put them on a path to improving their credit, but it is not an instant fix for resolving credit issues. It does cause the old debts to show as no longer owed. Once the discharge is entered, then their credit report will show discharged in bankruptcy for each of those debts. However, it now also shows the existence of a bankruptcy. And it actually will show that even if they don't complete the bankruptcy through discharge, the fact that your client filed a bankruptcy is something that does appear on their credit reports, and it remains on their credit reports for 10 years. Now, like any bad fact on a credit report, the more time there is between that event, that bad event, And when their credit is being reviewed, the less impact it has on their credit score. So typically, a person is able to, with good behavior post-bankruptcy, they're typically able to have a solid credit score between 2 and 3 years after the bankruptcy. And they'll get about 620, 650. That puts them back in the range for being able to borrow mortgages or do realistic car loans, not those predatory car loans. But that will continue to pull down their credit score for the full 10 years. So it's important that clients understand what they will and will not get from the bankruptcy process. And the other big thing that happened that you cannot do in a bankruptcy, you don't get to walk into bankruptcy and eliminate a mortgage. Mortgages have all kinds of special protections. We're going to talk about those more. But you don't get to wipe away the mortgages. You've got to deal with those mortgages. There are one of the other exceptions or special sets of rules for mortgages in bankruptcy is you don't get to play around with the numbers the same way you would with other debts. So I mentioned the example of a car loan, changing interest rates and paying less than the full amount owed. None of those options are available for most mortgages. You're going to be stuck with the original terms, the actual debt owed, and the actual interest rates owed for most mortgages. Okay, and when you're saving a house, we talked about how you can use the 13 to do that. You cannot modify the terms of the mortgage, but you can go through a loan modification process while in a bankruptcy. So if there's some change in circumstances and it makes sense to try that inside bankruptcy rather than out, you can go through that process. A lot of lenders will want what's called relief from stay first. And that's something you guys are going to learn about in the all-day training. If you have a mortgage, if you get one of those white elephant cases where your client's mortgage is going to mature within 5 years so that it will be fully paid off within the term of the bankruptcy, then you can start tinkering with interest rates and paying less than the total balance if your house is underwater. You got a lot more options. So when you're screening cases, you want to be looking for that. Are you in that rare moment where it matures within the 5 years of the bankruptcy? Yes, so you don't ever get to get rid of purchase money mortgages, and you don't ever get to wipe away mortgages that are in the first lien position. They get special treatment. However, every once in a blue moon, we'll have one of those cases where the client might have another mortgage that they took out not as purchase. It's in a second lien position, and the first mortgage consumes all of the equity in the property. So the second mortgage is wholly unsecured. You can strip that off. Your client can make that go away inside of Chapter 13. You can also raise underlying legal challenges to any mortgage, the validity of any mortgage. Those can be raised through an adversary proceeding, and a bankruptcy court can adjudicate that question just like any other court. And if they determine that the original mortgage is not valid for some reason, regardless of lien position or purchase money, if they say, yeah, that mortgage isn't valid, it goes away.
Jennifer,
Yes.
comment. WDPA Bankruptcy Court has a mortgage modification program debtors can participate in.
Okay, thank you for that. I'm not super familiar with how that works. Maybe that's something we could share more about after the training through those emails. So the email announcements that Kelly sent out inviting people to sign up for the training, maybe you could share more about that, because that is something that people in the Western District should know about. Thank you for pointing that out. So in terms of the mortgage and what you can do about a house, the mortgage company is going to file what they call proof of claim, which is where they lay out how much they think is owed on that mortgage. You don't get to just rewrite those things just because. However, if you have legal challenges for the accounting or the balances, maybe they're not applying funds correctly or they're charging too much for their legal fees or foreclosure costs, you get to go in and argue about all of that nitty-gritty. You can, even if there was already a judgment in place, if you're going to be curing the mortgage delinquency, then the judgment doesn't count. You can go in and you can argue about all of those fees and charges. And again, we also talked about the offset that's also available within a Chapter 13. Okay, so we don't have any of these. If you have a case where you don't have anything special, like you don't have a TILA or RESPA violation or challenges to fees, your client just fell behind, mortgage company is not working with them, and you want to use bankruptcy to save the house, you can do that. We talked about that. The really powerful place that we use bankruptcy all the time is when the client is not the borrower. I won't even do a poll. I know every one of you out there has had a client denied a loan modification for not the borrower. And if you haven't yet, you're going to go through that at some point. That is a great opportunity to use a Chapter 13 to resolve a delinquency if your client can afford it. Because you don't have to get the mortgage company to agree. As long as your client has some kind of interest in the property, presumably they do if you're trying to help them, that they're an owner or an heir, or maybe they bought the house from a previous owner, so they were in, and the mortgage traveled with the transaction. Think rent to own, ding, ding, ding. So anytime you have any of that, you go into bankruptcy, the mortgage company doesn't have a choice in the matter. Your client has an ownership interest in that house. That house is now a property of the estate, and that mortgage is now a creditor in that bankruptcy. And now you're going to apply the cure rules of the Chapter 13 process through your Chapter 13 plan. And the mortgage company has to accept that. As long as you follow the rules of bankruptcy, the mortgage company cannot object. The big thing in making that working is that you have to have enough money, the client has to have enough money in the budget to manage those two payments. They have to manage the new mortgage payment each month. That obligation doesn't go away. So they file the bankruptcy, and 2 weeks later, the next month starts, they have to have that money paid to the mortgage company for that next month. That's called a post-petition payment that they make to the mortgage company. And before Catherine says anything, I'm pretty certain the Western District requires all payments to go through the bankruptcy were not paid directly to the mortgage company. I know that one, but we can get away with it and pay outside of the plan in the Eastern District, and I believe also in the Middle District. Then they need to be able to pay that new mortgage payment each month. And then they also have to be able to pay that catch-up payment each month. And that's where you're going to spend a lot of time with clients. How do we make this budget work? Because if they're sitting in your office, there's some reason the budget wasn't working before. So what are they going to do differently next month that they weren't doing all of those months before? And I think we've already emphasized the bankruptcy for a Chapter 13 plan. It has to be a minimum of 3 years and a maximum of 5 years. So you have to make the money work with those numbers. When I'm able to write a 3-year plan, if my client can afford to pay it off in that shorter period, I do recommend that, because it gives you wiggle room if a problem develops or if the numbers change. Instead of having to find new money each month, you can just extend out the bankruptcy to a longer time period. But oftentimes our clients' budgets are very stretched thin, and you have to start at that 60-month plan and keep your fingers crossed that you don't have too many surprises in the case. All right, so there are some times where there are red flags, and it's really important when you're doing a screening process that you look for these flags, because doing a bankruptcy is an enormous amount of work for the practitioner, both the attorney and the paralegal, and you don't want to be going into these cases without knowing what you're getting into, because you'll get in there 2 months, you'll have done all this work, it'll blow up, and then your client's right back where they started, and even worse. When is bankruptcy wrong? When it's too expensive. Again, this is that budget problem. If your client cannot manage the new mortgage payment and the catch-up payment, then you've got to figure out how to solve that, or you can't go to bankruptcy. It has to be feasible. If what their goal is to resolve debts that are non-dischargeable. All right, I have clients who walk in here and say, I want to get rid of my DUI and stuff, and it's $20,000 in a judgment that. And I'm like, look, that's non-dischargeable. Or IRS debt, they'll come in for that. Or child support. So if that's why the client wants that help, it's not the right place for them. So again, we've talked a lot about this concern about making sure that your client has no unexempt assets. All right, and looking and making sure that equity in the house, anything, any collectibles, pending lawsuits. This is one that people miss early on. When a client is in the process of doing a lawsuit, and that can include an SSA appeal or an SSI appeal, those are monetary assets that have monetary value presently, even though they do not currently receive that money and haven't secured a judgment. All of those kinds of potential payouts have to be reported. You have to assign a value to them, and then you have to figure out how to exempt that value. And if you can't exempt the value, what happens is the trustee will take over the control of that lawsuit and settle it for a lower amount, and your client gets nothing. That's not a fun moment to be in. I've got a couple rounds of clients when they have pending lawsuits they don't want me to get involved in, and I'm like, look, you don't have a choice. Either I'm poking my nose into it or the bankruptcy is going to take control of this thing. So we got to figure this out before we file your bankruptcy, because I know you don't want your trustee taking over your case, your personal injury case. Okay. The bankruptcy process is a document-intensive process, and these are not optional. There are mandatory documents that must be produced on timetables that are set out by the bankruptcy law and the bankruptcy rules. Your client has to be able to produce these documents. And so, you want to make sure you're going through the checklist. I'll show you that in a moment. Actually, I will show you that right now. Okay. So this is the checklist that I use to track what my clients are, what the documents that I need are. So they need to do the credit counseling, and we need to get the actual certificate saying that they've completed that. We need proof of every source of income that they received in the 6 months prior to the bankruptcy. So even if they're not currently receiving that money, if they had a paycheck 5 months ago, we need those pay stubs. Tax returns that were due filed within the 4 years preceding the bankruptcy. All right, and that's all required returns. Anything that legally your client should have filed, you need to have the copies of. And you'll notice I said 4 years, but all of a sudden we have 5 years here. And that's because the 2014 taxes were not owed until April. That's still within 4 years of where we are today. But if your client has already filed their 18 taxes, then they also need to produce that, because that's also still within the 4 years of today. So, and when you're going through that process, you also need to make sure that they don't have a refund owed to them. And trust me, the trustees are looking for that. They ask that question every meeting of creditors. What's going on with the refunds? And you need to schedule that IRS refund on the schedule as an asset, and you need to exempt it, or the trustees will take that money. Okay, other documents they need. A valid government-issued photo ID. Do not take your client's word for this. Trust me, I've been there. Actually make them pull out the ID, look at it, and check the expiration date on it, and then take a copy of it. So, because if that is expired on the day of your meeting of creditors, you have not successfully completed the meeting of creditors. So if there is a problem, you want to identify that problem early in the case and get your client working on solving that problem well in advance of that meeting of creditors. The same thing goes for the Social Security card, and then also insurances for those assets. If they have a home and a car, that they need to prove that they are both insured. And bank statements for the last 6 months for any account with the debtor's name on it. This is an area where clients often underreport what actually exists. They have their name on mom's bank account because they help mom pay her bills, just as helping her with Social Security and stuff like that. Client's money isn't in the bank account, just client's name is on the account for access. Because their name is on the account, it has to be disclosed in the bankruptcy, and those documents have to be produced, period. These are not debatable points. Let's see, bills, recent bills. This is not actually a requirement, but it's really useful when you're putting together the budget. Credit reports, that's part of your due diligence. You need to have your credit reports, their clients' credit reports, so that you can try and capture as much debt as may exist.
Jennifer, we have a question.
Certainly.
Me. If they get the renter's rebate, do they have to report that too?
Yes. It's money. It's income. It's, yes. Yeah, and again, it's not that you should be afraid of reporting, okay? Report and exempt, and that's part of what we're going to talk about in the training next time. But it's, it is so much better for your client when you identify everything in advance and it's all reported and you have all the documentation to back it up and you can explain why the trustee isn't allowed to touch it and everything goes nice and smoothly in your bankruptcy process. Okay, so I know I'm running a little short on time, so I'm going to get through this. Sorry.
And if I could quickly just launch the second poll for CLE credits. If you're an attorney and would like CLE credits, please respond now. Thank you.
Okay. So one of the other things that comes up in this process is when clients are not able to get documents. For instance, they need mom's bank account. Remember we talked about if client has their name on mom's bank account and she doesn't want to give them the bank statements. All right, or if you have an uncooperative spouse, spousal income must be reported in a bankruptcy. We'll talk more about that in the next webinar. But if they have an uncooperative spouse that they're living with, that's a problem, and that's a big problem. That could be an insurmountable problem potentially. Under the table income, if you have a client who's working under the table, you need to put the brakes on bankruptcy. There are ways that can be fixed. We're going to talk about that in the next slide. But you cannot ignore that issue. You cannot file a bankruptcy with that being the status quo. You have to legitimize that income before you can do the bankruptcy. Okay, previous bankruptcies. So there are restrictions on people going into bankruptcies repeatedly. You can only get a discharge in a Chapter 7 once every 8 years. Okay, now we're talking about 13s, so you have some different rules there. If a person has done a previous Chapter 7, they are not allowed to get a discharge in a 13 unless their new 13 is filed 6 years after the discharge in the 7. It's actually 6 years after the petition from the discharge that obtained a discharge in the 7. But that's okay because you can still do a bankruptcy. You can still do a Chapter 13 within that 6 years. They just won't get a discharge at the end. But they can still impose a reorganization plan. They can still do a catch-up with a mortgage company. They can still litigate all that other stuff and get the court to order what the amounts are owed. So you can still use 13. You just may not get the discharge at the end. So your client may have more debt they have to address outside of bankruptcy. As complicated as bankruptcy is for us as practitioners, it is also complicated for our clients. And there are some clients for whom they are not going to be able to effectively navigate the bankruptcy process. You need a certain level of functionality and follow through from a client. They have to be able to come to a lot of meetings with you in your office. They have to be able to get to court. They have to be able to locate documents when you say, hey, I need this document, can you please get this? And it's not just going to be one piece of paper, it's going to be 20 pieces of paper, and then another 10, and then you're going to need another 5 that come up. And if you have a client who struggles with those really basic tasks and finds it incredibly difficult to do those things, you may need to have a serious conversation about whether or not this is something they're capable of doing. Because a bankruptcy will crash and burn if you have a client who's not able to show up for meetings and give you the documents you need. I just had one in the past year where this happened, and it's a consideration, and it's something that you want to make sure that you are talking with your client about if that's a potential issue. And sometimes, particularly for people who are elderly, who may be kind of losing some of their functionality, sometimes you solve that problem by having a helper or by finding somebody who can come with them to the appointments, bring them to the appointments, bring them to the court, help them get their documents. And sometimes that's like the impetus to get them to invite a family member into their lives in this transitional point where they may have been hesitant to do it before. So it's not necessarily a bad thing, but you want to be on the lookout and make sure you address that in advance. Then we have another kind of client. And that's the why do you need that client? I've had quite a few of those over the years. And this is the person who, for whatever personal reasons, does not like sharing information, feels that it's none of your business how much money I give to my church. You don't need my bank statements. I don't want to give them to you. You know, people are entitled to their privacy. And I'm not saying that it's wrong for people to feel that way, but the bankruptcy court does say that. When a person files a petition and requests the protections of the bankruptcy court, they are surrendering their privacy with regard to their finances. And that's the entirety of their finances, their income, their assets, their debts. You don't get to pick and choose what information you tell the bankruptcy court. It's all or nothing. So if a client is somebody who guards their privacy, who doesn't like to share this information, this may not be where they want to go. And I have had clients where I've had that conversation and I've walked them through everything that's required and they say, no, I don't want to do that. I say, okay, that's fine. So let's talk about what we do without using bankruptcy to solve your situation. Every once in a while, you get that client who feels like it's morally improper to file a bankruptcy. That's, again, people are entitled to their beliefs. I do sometimes try to push back a little on that. The concept of bankruptcy actually comes from the Old Testament in the Bible. And it's actually an obligation, a moral obligation of the creditor to release people from debt every 7 years. And so people who are concerned that they are violating a moral duty to repay debt, I often will provide them this historical understanding. And sometimes they want to go back and talk to their pastor, and then they come back the next week and they're like, okay, I'm good. And they're good to go. That's less likely to happen if you're dealing with somebody from an Islamic tradition. They have a different concept of debt, and it's a harder sell if somebody is raising that concern. I don't think that they adopt that same concept from the Old Testament tradition. Okay, and again, some people are concerned about the impact on their credit. Other problems. We've talked about equity in the house. If you do have a client with lots of equity in the house, in a 13, they can still keep the house if they pay to the unsecured creditors the amount of money that is owed that's non-exempt equity in the house. So if they have $35,000 of equity in the house, 25 of that is exempt. That means you have $10,000 non-exempt. If they owe $20,000 to unsecured creditors, that's credit cards. Inside the plan, you pay $10,000 to unsecured creditors along with whatever you're doing for the car loan or the mortgage, and then they can still keep the house. Unreported income, this is that under the table stuff. The way that you fix that problem for someone who wants to do bankruptcy is they have to go back and file taxes for every single year in that 4-year window for which they have unreported income. I will explain this to clients, and the vast majority of them never come back. They just don't want to do that. They'd rather deal with their situation a different way. But this is a way they can legitimize their income. If they go and they report their income, so it's no longer under the table, they're okay. They then have to continue reporting their income and make estimated quarterly payments going forward to the IRS. And they can do this even if with an uncooperative employer. If you also may have a client who is filing income, who has over-the-table income but hasn't been filing their taxes, that is a no-go. They must file all required taxes with all required taxing authorities before you can file the bankruptcy. Well, I take that back. It has to be done 7 days before the first scheduled date for the meeting of creditors. But I will tell you right now, personally, I don't file a bankruptcy if my client has a tax problem, meaning they haven't filed taxes. They need to show me they have filed before I will go into the bankruptcy. They do not have to pay the taxes. They can file bankruptcy and owe the IRS. That is okay. They just have to have done the paperwork and filed those returns. Okay, and all taxing authorities means local and state as well as IRS. And for some of us, if our clients are living in one locality and working in another, they could have multiple local locality obligations to file. And if a person has a pending lawsuit or is expecting a reduction in their income, now might not be the right time for the bankruptcy. Maybe you want to wait and time the bankruptcy at a later point. And I know I'm out of time. Talked about this already.
Jennifer, we have a question.
Certainly.
What about clients that don't file because they don't earn enough? $600 mortgage payment is doable on $1,300 SSI.
Okay, so if they're not legally required to file a return, then they are in compliance with the law, with the tax code, and that is fine. So that's not a problem. But a lot of clients misunderstand what the obligation is, okay? Many people think that you're not required to file if you're not getting money back or if you don't owe money. That's not correct. If you have self-employment income of $400 or more, that triggers the obligation to file a tax return. So if you've got a client who's doing a dog walking or babysitting or doing hair on the side as a way to make ends meet, they're going to have to be filing taxes, and they don't realize it. And many, many people are in that situation that I deal with. Another way that they have an issue is that they are getting taxes, they're working. I think the trigger for working is like $8,000 for a single person. I haven't looked it up in a while. So they figured, oh, well, I'm paying my taxes in my pay stub, so why do I have to file something? That's not the law. The law says you have to file if you hit certain triggering events in this kind of income and the amounts. So if you know, I mean, if your client has benefits like pension or Social Security, you're right, they're not going to be required. If their only income is Social Security or SSI or TANF, you are correct. There is no legal obligation to file taxes in those instances. So yeah, that's okay. But many people do not understand what those triggering events are that do require filing. Okay, bankruptcy in 9 easy steps. So today we've talked about the pre-bankruptcy, or we haven't even talked about the pre-bankruptcy. So after you figure out your client needs a bankruptcy, these are the different steps that the client's going to go through in the bankruptcy. And we're going to talk about most of these in the next webinar. So I'll skip that for now. I think we've talked about gathering information. So there's a lot of due diligence when you're preparing a bankruptcy. You cannot just take your client's word for everything. You have an obligation to, look at whatever publicly available records there are, credit reports, county recorders of deeds, the county prothonotary or clerk of court to see what judgments may exist or pending cases. We have a website where we can look up tax balances that are owed on properties. If there's other databases like that, the home valuation. So you're not going to take the client's word for what the house is worth. You're going to look that up on a website, a real estate website like Zillow or Trulia to get some market valuations. If you have Lexis and Westlaw, they have data search options that can be useful for creating reports that compile all of those various public records. And if you have access to those kinds of record options, search options in your legal server database, I'd recommend looking at those. Okay, so for the attorneys in the room, you got to be admitted in the federal court in your area. So being admitted in Pennsylvania isn't enough. You need to go get admitted in the Eastern District or the Western District. You need to have an ECF, e-filing account for bankruptcy court, not a local district court. So if you have an Eastern District of Pennsylvania ECF filing, that's not good enough. You have to get one with the bankruptcy court. And if you have a PACER login, that's not the same thing as an ECF login. And I emphasize these things because the last thing you want is you go through prepping the whole thing for the bankruptcy, and then the day you're trying to file, you realize, I don't have a password or login, and I'm not going to get one for 3 business days, and how do I file this bankruptcy? You do not want to be there. So if you're going to be doing bankruptcies, get all of these things taken care of well in advance of when you file your first bankruptcy. You absolutely positively, your office needs to invest in some kind of a bankruptcy preparation software. Just like tax preparers use some like TurboTax or some equivalent that fills in the forms, bankruptcy preparers use Collier's or Best Case. There are others out there as well. Well worth the investment. It avoids problems. It makes sure that we get things right, and it makes sure the forms are filled out correctly. There is a bankruptcy code, which is the law, and the bankruptcy rules. You have to be able to access those there's a great desk set that we have that we get for people who do bankruptcies in our office. They're also available readily on the internet or through Westlaw or Lexis, or you can also get them on Legal Information Institute. So there are different ways you can get those, but you really can't practice bankruptcy without being able to look up those codes and the rules. NCLC has a spectacular reference book on bankruptcies. So if you're going to be doing this, it's worth getting that reference book as well. There are also a whole host, all of the trustees are now moving into electronic databases for things. So figuring out how your office needs to communicate and transmit documents to the trustee and understanding those protocols in advance so you're not tripping up on everything. Think about the logistics of how when your client needs to pay the filing fee, how are you going to get that to the court? What pre-bankruptcy credit counseling services are you going to tell the client? Because you're going to say, hey, you need to go get that counseling session before we can file. And the client's going to look at you and say, where am I supposed to do that? So figuring out like what you're going to be telling the client as you walk them through this process. And then when you have time, if you're going to be doing these in volume, creating standardized letters and checklists, and what kind of staff support and how you want to divvy out the workload of these cases. Usually our office uses an attorney and a paralegal that work in partnership on these cases, with the paralegals doing a lot of the data entry and client meetings in the beginning, and the attorneys handling the court appearances and the motions filings and adversary filings. And that is it. I apologize I ran slightly over. I will remain available if people have further questions.
If you have any questions, please type them in the chat box. We do have one already. Will this PowerPoint be available to save? I'm assuming the slideshow.
Yes, so the entire webinar has been recorded and will be available on Plan's website. And Kelly, you're free to circulate this PowerPoint. I'll email it to you if you want to put that on separately.
Okay, so everyone will receive the PowerPoint by email. Probably not today,
Kelly,
but shortly.
Do you need to do the second CLE survey?
I did it already, actually. We're good.
Oh, I'm sorry.
Okay.
Fantastic.
You were in the swing of things, so. And I'm not seeing any more questions coming up, so we could probably wrap it up here. And if people have any more questions, they could reach out to you or the listserv or whatever.
Yeah, just post it to the listserv. I think people, are going to think about things. I know we covered a lot today, and we're going to also cover a lot the next time. And Catherine, I really do encourage you to please share more about the Western District's mortgage modification program. I do think that everyone would benefit from understanding that better.
Okay, well, thank you so much for your time and expertise today, Jennifer. We appreciate it.
Absolutely. Thank you so much.
Thank you. Everyone have a good weekend.